Perfect. And we're live, everybody. Welcome in. It is Wednesday, January 31st, 12 p.m. Central, 1 p.m. Eastern, 10 a.m. Pacific. Sometimes I get Eastern and Central mixed up because I used to live in the East, Northeast. I have Richard from Not Legal Advice, amazing YouTube channel that covers legal proceedings and a bunch of other stuff. Richard is a lawyer. And for this conversation, as it pertains to the latest ruling out of Delaware, where a judge essentially rescinded Elon Musk's $55 billion pay package that was assigned to him back in 2018. We're going to sit down, dissect what the heck just happened. We've had a little bit of time to digest the information. There's been a ton of discussion around the action, and what I thought happened is not really what happened, because once I started talking to Richard about what just happened here, Richard's like, I'm not really sure people actually know what has actually happened here. So we actually have a lawyer that's going to help us understand what the hell just happened. So maybe for the audience, Richard, since I'm sure a lot of people have read the news, have digested the news, maybe give us a foundation to start on.
Sure.
And then we can discuss what the heck's going on. So please take it away, and please don't bill me for this, okay?
Yeah. Well,
this is a friendly consultation, okay?
Yeah, I can't promise that, the latter. And
what a lawyer would say.
If I go too long here, just kind of cut me off and
yes, sir.
Stop me.
I got you.
Okay. So the action was filed by a shareholder. The shareholder had 9 shares. That was his total ownership, but he has standing because he is an owner. And a class action was filed. Now it was a derivative claim, which means that the claim would benefit the company as opposed to the individuals. So any recovery would go back to the company. The person had individual claims too, saying he had been damaged, but those claims were dismissed. So there were a couple claims that remaining, and there was a trial. The trial happened in 2023. It was a 5-day trial. It was a bench trial, so there was no jury. This judge was the same judge who was handling the Twitter purchase that never went to trial because it was resolved. So 5-day trial ended April of 2023. The judge had been considering that the matter since then. What's outstanding right now was the order, and the order of the court was that the fee agreement that was entered into in 2018 was rescinded. Now, so I've seen people reference that it was voided. It wasn't voided, and it wasn't canceled. If it was voided or canceled, that would be different. Go ahead.
So help define rescinded specifically as it relates to this.
Yeah. So if it was, and I'm going to give you the distinction. So voided canceled means it doesn't exist and it can't be renewed. So it's done. So okay. I just for an example, I had a case recently where I represented the church. There was an issue about a deed of trust on the property, and I was seeking the cancellation of that so that it was not only gone, but it couldn't be revived. What this judge said was it was rescinded. And what rescission is you put the parties back in the same position they were before the agreement. So in essence, what you're doing is you're going back to 2018 and you're letting the parties start all over. The judge didn't decide. So that's the basic ruling. The judge found that the price and method of establishing the pricing of the agreement were unfair. And that's why she ruled as such. And how she got there is interesting. And here's the part I don't think anybody's talked about. So and this is Delaware law, obviously not legal advice because I'm not a Delaware lawyer. But in Delaware, when they decide these type of actions, and the reason why Delaware decides a lot of these actions because at one point in time, Delaware was perceived to be a really friendly place for corporations. So everybody incorporated there. Over time, obviously, that's changed. So in Delaware, under the law, when they're evaluating a breach of fiduciary duty, so if you're an officer or director of a company, you have a fiduciary duty to your shareholders. So,
And sorry, just to also explicitly explain that fiduciary duty basically means that you have your investor's best interest in mind when you're making a decision. Correct?
correct,
Okay.
correct. So, in a lot of states, when you're examining that, you're examining the actions of board members, et cetera, they use something called the business judgment rule. And basically, you evaluate what's going on. And if you have a reasonable basis for making a decision, that's good enough and you're safe. In Delaware, they have kind of a different structure. And so they look to see who has control over the corporation or the entity. And based upon that, they decide which rule to apply. So there's a business judgment rule, there's a middle rule, I didn't remember what the name was, and there's a third rule, which is a fairness. It's a total fairness rule. And it's based upon control. So if the court finds that you have control over the corporation, then they can impose the fairness rule, which this judge did. And what's significant about the fairness rule? It shifts the burden of proof. So normally in a case, the plaintiff has the burden of proof of establishing the elements they have to succeed on a claim. In this particular matter, because the judge found that Elon controlled the company, she said that he therefore has to be judged by the harsher rule of fairness. And under this harsher rule of fairness, he has an obligation and burden of proof to prove that both the price and the procedure were reasonable. So it shifts the burden of proof. Normally, he would just have to respond to whatever plaintiff. In this case, he had the burden of the plaintiff. And the judge said, in essence, that he didn't satisfy that burden. And the reason why the judge stated that, in part, one, in terms of the amount, the judge focused on the amount, and she compared it to other executives that had gotten paid, and the amounts that he got were substantially more than anybody else. So she deemed that improper and unfair. And then in terms of the process, she looked at his ownership. He owned 21.9%, I think, ownership at the time. He kind of controlled the timing of this particular transaction. She claimed there was no real negotiation about the terms. The only negotiation I think that were discussed were there was going to be either 10 tranches, 15 tranches, or 12 tranches. So, and a tranche is basically a division. So 2018, they're going to divide up over a period of time into 12 parts. He has to meet certain goals, certain milestones. They were connected to market cap. From, I think when he started it, the market cap was $50 billion. And it went up to, I think, $650 billion was the top of the market cap. And he also had to meet another standard, either EBITDA, which is earnings before interest, depreciation, taxes,
yeah, amortization,
or revenue, or a certain increase in revenue. The judge believed that they knew that he would be able to easily meet those milestones. So based upon all that, his control of the stock, the timing, his control over timing, the lack of negotiation, she deemed that the process was unfair. And in the process itself, there were 6 board members that voted. 2, the Musks didn't vote, and 1 was out of town, so didn't vote. But the vote was 6-0. Then the shareholders voted. 73% voted yes, so it was approved. But the judge said that the proxy documents didn't disclose the relationship of Musk to the board of directors. And so it didn't, as such, since it didn't disclose those details, it made the vote as if it didn't occur. So it didn't ratify the actions of the board. And as such, That's why she, in essence, found as she found. Now, I thought it was interesting. She certainly focused on his wealth. She really did. Because she mentioned it many times. And unfortunately, I think she has a dislike for him. And in 2023, he testified. No, it was 2022. I think it was November 2022. He testified in this case. It was right in the middle of the Twitter, the start of the Twitter stuff. So on one hand, he's talking about his compensation package and the need for compensation. On the other hand, he's in the middle of the Twitter transaction and complaining about having to pay, etc. And I think he pissed her off. Obviously it shouldn't have impacted the decision, but I think from a practical standpoint, it was bad timing. And if we bring it up to the current time, she obviously knew that he was seeking a new compensation package now because he referenced it. So it was in the public sphere. And I'm wondering if she thought by throwing this monkey wrench out, it might impact his ability to get a future pay package. And if she was being vindictive, it would be a way of her doing it. Now, I don't think it does that because, and I was talking to people yesterday. So what can you do? So you're back to 2018. And by the way, she left it to the parties to figure out the language of the judgment. So in part of the ruling, it says, so my ruling is to rescind the agreement, but why don't the parties figure out the language of the judgment? So you guys get together. They won't be able to get together, by the way.
1 second. So when she says you guys get together, does she mean the board gets together and come up with a new language, or the plaintiff?
The attorneys for both the plaintiff and the defendant are supposed to get together. They're supposed to agree upon language of a judgment. That's not going to happen. She will ultimately be stuck with it. Now, rescission, like I said, puts everybody back in the place they were when we started, but you can't, right? If you think about it, what happened since 2018? For example, Elon would not have bought Twitter if he didn't have this fee deal. People wouldn't have been fired from Twitter. People wouldn't have been hired at Twitter. There's a whole bunch of actions that happened after 2018. So in my mind, and I was going to address this down the road, but in my mind, the remedy that she chose, rescission, is the wrong remedy, because I don't think you can put the genie back in the bottle. What would be an alternative to rescission? You could just award damages. I mean, you could say that Tesla's been damaged, and you could put an expert on, and they'd figure out some calculation, and that would be discernible. It may be the case, by the way, that the reason it wasn't that way is because it was difficult to calculate damages, and if you tried to, you wouldn't be able to. But the language, the final language, hasn't been decided. So we're probably another 90 days from the final order. And at that point in time, the order can be appealed. But what could be done in the meantime? In the meantime, you could draft another fee agreement for Elon. You could have it go back to 2018. You could present to the board with full disclosure. In essence, you just follow what the judge said. So the judge had a problem with what was included in the proxy materials, about what was disclosed about relationships with directors. What you would do is you disclose all that. You'd attach a copy of the court judgment to the proxy materials. You lay it out in front of everybody, and it would pass, by the way. And you could either reinstate that 2018 fee agreement, or you could amend it and start a new one. But for me, when I was thinking about it, what it does is it lets Elon get that future fee agreement done now. No, he just raised it. In effect, it's been put in his lap because that now has to be dealt with. It has to be dealt with because of this judgment. So I think in large part, if you look at the stock today, it's flat. It didn't drop. Last night it dropped. It was down like 3%.
5%
over
at
hours.
peak.
Yeah.
Yeah.
But I think people have contemplated that they've in the long run, it may have been it presented the opportunity to get an issue that needs to be resolved and immediately. And I still think, by the way, so I think that they can go in, they could present a new fee agreement, but I still think they are going to appeal the decision. And they could do both. They could bring a new fee arrangement to cover the 2018 period and future, and still appeal based upon the grounds that were stated. So that's kind of my little blurb. And if you have questions, I'm happy to answer them.
I have many. And in the comment section below here, let me see if I know how to produce. In the comment section below, we'll also be doing Q&A, if that's okay, Richard, as well. Yeah,
sure.
Because there's so many questions here. Okay. So where my mind first went to, as you were describing how the judge arrived to the ruling, which I actually find extremely fascinating. How did she decide? So, and this is where I'm confused, right? Because this is not my area of expertise. So a public company has a board, and the board, in theory, let's just think in a perfect world, the board is designated to be there to ensure that all the executives are doing their job and ultimately ensuring that they're meeting their fiduciary duty, right? Making sure that the investors are being taken care of here. Okay. How did the judge decide that the control was on Elon and not the board? Like this, that's where I'm confused. Like if that was part of the ruling, help me understand that control piece a little bit better.
Yeah. So in addition to the other factors I mentioned, she kind of went through each of the board members. She indicated basically that their wealth, it came from Elon, their relationship with Elon, that they became investors, and because they became investors, they became all super wealthy. And as a result, they really couldn't say no. So that there wasn't any real free will of the board. And in all reality, Elon still controlled these people. That was kind of her position.
So they got paid.
In addition to the fact that he had 21.9% ownership, the facts of how the deal itself were negotiated, etc.
Okay.
She also said as to the board that they had an obligation to get the lowest price for the company, for Elon, not let him get whatever he wanted, but to get the lowest price, or to, and I found this kind of funny, but whatever, or to go out and find a replacement. That was an obligation of the board. So the second one, whatever, that's complete lack of understanding. But the first one, she said, if he asks for 55 billion, you can't just say yes. That was her position.
Okay. So let me say that in maybe different words. The judge felt that there wasn't enough of a back and forth, or like a haggling process between the board and Elon to arrive to a quote unquote fair price, because the board, in her eyes, was too closely tied to Elon, which then enabled this environment where Elon basically got his way in the pay, and the investors weren't privy enough of the relationship between Elon and the board, and the company wasn't transparent enough about that relationship in their proxy statements and when they created the vote. So even though the investors voted yes overwhelmingly for him to get the paycheck, or the payout, the tranches, in her eyes, the company didn't do, and Elon didn't do a good enough job in ensuring that everybody understood the relationship between the board and Elon. Is
Correct.
that okay?
Correct. Yeah.
Right.
The disclosures prior to the vote weren't sufficient.
Okay. So why? I guess the pay thing that she talked about, where you already have 21% and you're getting more. Why is that part of the equation at all? So if it's about transparency, why is that part of the judgment?
Because it was a two-pronged test. One was the price had to be fair, and the process establishing the price had to be fair. So she compared it to every other CEO. She references, I think she referenced Bill Gates or somebody, and nobody, I think it was, she said it was 25 times larger than the next largest package. Since the fairness of the price was a factor to be determined, according to her analysis, that's why it came into discussion.
Why does a judge in Delaware get to decide what's fair compensation? That's where I'm getting, like, so it was of a large, and maybe this is the specific thing that I'm stuck on. Why does she have the ability to dictate what fair compensation looks like?
Well, because somebody filed a lawsuit and it survived a motion to dismiss. So the claims were that the pay package was not fair. So it wasn't her. She didn't break, even though I think she's got, she's got a bias, I think. In this
and
case.
I'm not trying to say she's biased or unbiased. I'm just trying to understand why is that part of the, like, why comparing his pay to other people's pay a sort of variable that gets analyzed here when it's just more talking about the transparency.
Because the legal question required a two-prong view of, it wasn't her making up that she had to look at price and fairness. The law in Delaware is, if the burden shifted and he's got control, then we have to look at both the price and fairness.
It's part of the process.
So again, it's not the end. It's the procedural twist that she did where she shifted the burden of proof, because that changed how the entire case was handled. And
she decides that variable, right? So that it's up to her. Okay.
And let me address. So, I think Elon's going to appeal, and one of the issues he's going to appeal on, I believe, will be that issue. For purposes of this statute and this ruling, was this adequate control over a public company to shift the burden of proof? I think that's going to be one of the issues. And and it's a public company. It's not like it's a mom and pop company. He doesn't run everything. So I think that's a reasonable position and a reasonable argument.
Okay, got it. Okay, so I understand that better now. I appreciate that. Okay, is this ruling unprecedented when it comes to, like, is this because one of the headlines I was reading was like, this is unprecedented, this is crazy, this has never happened before. Help me understand how big of a decision this is in context to other decisions.
Yeah, I think in Delaware, it's huge. I believe it's unprecedented in Delaware. And again, Delaware is going to have a lot of these cases because a lot of companies are located, and it's going to, although it's a trial court decision. So in terms of precedence, you could say, we could talk about this case, but in terms of another judge having to follow this case at this level, it's not required. So it's only a trial level. If it goes up on appeal and the plaintiff wins, then other judges in that area will be required to follow that logic. And then that means that every pay package for every CEO in Delaware is going to be at risk. And as one of the, and I think Elon even referenced it yesterday, and as a result, I think what you're going to see is a whole bunch of corporations now reincorporating elsewhere because they don't want to be subject to this possible risk. And I think that's why Elon talked about Texas. I think he talked about Texas yesterday. Texas, Nevada. I mean, that was the discussion yesterday, because those have a little bit less control over the companies, less abusive of their interests.
Got it. And so what this could mean, so just to re-summarize in my head, what this could mean is that if this were to be appealed and the appeal was won by the plaintiff, which is the person that brought forward the case, in this case, the person with 9 shares, then starting from that point forward, every company CEO would be at risk of their pay packages being rescinded if a shareholder from those companies were to bring a similar type of case to trial.
Yeah.
Is that a fair?
And I think it's not even if it goes to appeal. I think it's now there's a judge
from this point forward
who might say it. So I can't take the risk. So I think it's already the genie's out of the bottle. And I think for Delaware, it's going to be a financial disaster, because they're going to lose a lot of fees from all these entities doing business there. I don't think Delaware has a lot of other huge businesses, but in terms of incorporate, I mean, I became a lawyer 40 years ago. Delaware was the place. Everybody knew that's where you filed. So I was going to address one thing about the plaintiff. So the reason why the plaintiff is with his 9 shares, because when you're a lead plaintiff, you get a bonus. So the law firm will give him, it might be $5,000-$10,000. And I believe this particular plaintiff has done it with other companies. So this is not the only company, but so he has 9 shares, whatever that is. And he might get 10 grand out of it. So for him, it's worth it. And what really controls this, and what is left, by the way, besides the language of the decision, is the attorney's fees. So
that was going to be one of my questions.
So plaintiff's attorneys will be filing a motion for attorney's fees. I think it will be a sizable amount. Generally, they won't allow, I don't know if it's going to be an hourly request. So they'll figure out they spent, 2 million hours times $500. I'm making up numbers. Or it's going to be a percentage of the amount of money saved by Tesla by this decision. Could be either. Usually they limit that to like 25% of whatever that amount is. And I know that it was, I think the fair value of the options before being exercised, I think was like $2.5 billion, something like that. So maybe they're going to seek, I was trying to figure out what they'd seek. Maybe they're going to seek like $650 million in attorney's fees, which would be a nice payday.
Cha-ching.
Yeah, it would be a nice payday if you could find it. But that's what's really gonna control this case at this point in time. Because from Tesla's standpoint, and from a shareholder standpoint, it's the odd point is we benefit in the short term, right? Because that $2.5 billion is going to be reversed, and it's going to be a positive impact on EPS going back in time. So in essence, it's a forced buyback of a small amount, but that's like a short term. That's just the short-term thing. If we lost Elon, that would be a disaster. But
yeah, okay. So this has been so incredibly helpful to help me get my head wrapped around this, because there was a lot of excellent commentary in the last sort of like 16 to 24 hours, however long it's been since the news broke. But this like really helps me crystallize why the ruling was, and we can argue if the ruling is correct or incorrect, right? Because there is a lot of variables there. Clearly, Elon's very unhappy. A lot of Tesla investors are very unhappy, which I find oddly at odds with the ruling, because the ruling was made in the best interest of investors. Yet I'm hearing a lot of investors are not happy about the ruling.
One thing we talked about was, I think there's bias, but I don't know. But it took 9 months to draft the opinion. So in my view, the fact that she was aware of Elon's desire for a new pay plan factored in, but it's taken 9 months to draft it. So it's not like, she just drafted it last week. It's been over an extended period of time. So I don't know how much influence like other events have. But again, just sometimes judges have dislikes for people, and they don't have to make correct or rational decisions. And it's up to the injured party to appeal. I remember there was a judge, he would go to a judge in a superior court, and he would start off each session. There'd be like 50 lawyers in his room, and somebody would bitch about some ruling he made, and he'd say, I got a room full of reversals on appeal in my office. If you don't like the ruling, file an appeal. Some judges are like that. They don't care. She has a dislike for Elon's position. Let's just say that. The Twitter position obviously was clear that she was not liking his position. Here, her decision to make a procedural change in who was required to prove up the case was a significant move.
Who pick? Okay, so this is like it might be a stupid question. Who picks the judges?
It's a random. So
Okay.
Yeah, in like, if I go in California, if I file a case, it's just whoever the judge pops up, and you generally have one shot to get rid of the judge, a free shot. If you don't like the judge or you had past negative experience, but the flip side is if you get rid of the judge, every other judge knows you got rid of that other judge, and you're concerned that might negatively impact the next judge, and you can't get rid of that next judge. Yeah, I know.
What a cluster. What is this? Oh my God. Okay. So let's start talking about, actually, let me see if I can pull in a couple questions before we hit a sort of the second stage here of this discussion. Cause I also want to talk about what are the next steps, right? Cause there is, I think obviously appeal is going to be one of them. What Tesla decides to do in parallel with the appeal, potentially, how this impacts Elon, how this impacts the rest of the landscape in Delaware, because it does sound like this is not just a Tesla Elon thing. This is a Delaware thing where a ton of companies have incorporated in that state. Do ask questions in the comment section below. I will make sure to bring those questions forward, and then maybe Richard, we can get your commentary. I want to bring this one up. Honest Broker, somebody on the comment section that typically brings counter type of commentary, which I really appreciate. A bigger lesson here is, while I think Musk's pay package was fine, hurting one's reputation and having a lack of an independent board is inviting needless problems. So do you have any commentary here? Do you think this is a valid concern? Maybe this is more opinion than fact, but yeah. I would love to hear your thoughts here.
I think, in my opinion, would be it's a valid concern, but I also believe that notwithstanding that this judge would have found some basis for finding as she did, because she really had to be. This is an aggressive ruling, so the judge really had to be an activist judge in here. So I just believe she would have found some other basis for concluding the same way.
Okay. Here's a great question from John from X. Does the Delaware Supreme Court automatically start to review this, or is it upon request? It's
upon request. We're not final yet, because we don't have a final judgment, and we don't have the attorney's fees. So until that's final, it won't go up to, it won't be, because either party could ask. Obviously, plaintiff will not ask. They'll be happy, unless maybe the attorney's fees are too low. They could appeal based on that. But Elon and Tesla are the ones who can file the appeal.
Got it. Here's a comment from Mimi. Please be clear when you're stating your personal opinions. You don't know if the judge dislikes Elon. How do you take this comment from our good friend Mimi?
I skimmed the 200-page opinion. I followed the last litigation. I have experience with judges, so I feel comfortable with that conclusion.
Nice. That's a very lawyer answer. From Matt, why not just have a board vote, then a shareholder vote, and have this settled by 2024? Either the old package or a combined future package. Just make sure burden of proof is met.
It can't be done that way. I mean, that's kind of what we had discussed. Yeah, you can't present it. You just have to make sure everything that the judge indicated was a problem is covered. And like I said, attach a copy of the judge's ruling to the proxy.
Okay. In an appeal, can other businesses join the appeal in a formal way?
Yeah. So can other businesses join? No, but there are something called Friends of the Court briefs, amicus briefs. So if you have an interest, you can file a brief in support of either party. So Tesla shareholders, for example, if there was an appeal and they wanted to show they supported Elon and they think he's worth every penny and they would have voted anyway, they can file a brief with the appellate court.
I'm going to bring a couple more too, and then we'll talk about steps forward. Can Tesla ask shareholders to vote on the 2018 convention again to keep it in place?
I think they could, but I think it would have to be modified in some way to reflect the judge's concerns so that it was bulletproof.
Okay. Tesla Boomer Mama, do we need a shareholder proposal for the proxy? And if so, would Richard help us draft it? For a fee, I'm sure he'll do anything.
I think you probably should be as formal as possible and cover every base. So yes, I would say yes. And you probably could find better people to help draft it, but I'm happy to participate in any way you'd like me to.
Okay. Oh, that's such a nice guy. Okay. So let's talk about steps forward, and then we'll do another Q&A as well towards the end. So here, let me do. I'm so bad at producing my own show. My God. Here we go. So steps forward. You have an appeal. You have an appeal, and Tesla drafts a new plan that would go back in time in some way.
Yeah, it could be a new plan or it could be an
yeah.
amended plan.
So help me understand the difference there.
So you could have an amended plan. You could amend the 2018 plan to just cover the period of the 2018 plan, or you could amend the 2018 plan to have it extend through that period of time and include the future time, or you could just have a completely new plan that has nothing to do with the prior plan, could have the same terms, but different other terms in it. So amended means you're taking the old one and just changing it, as opposed to a new plan would be just starting from scratch.
Mm-hmm.
But in essence, the judges put everybody back to the same position. Again, back to 2018. So it's as if no plan had existed.
Yeah. And it's important to also remember that this is a plan that has already hit its thresholds, and so that 55 billion was just waiting to vest over the next 5 years, right?
Yeah, and as Alexandra stated yesterday, none of it's been paid out. So I mean, there's been no harm, no foul at this point in time, because you can imagine if he had exercised the options already, then that would be a much harder genie to put back in the box, because money would be distributed, people would have been paid, and it'd be hard to rescind that kind of transaction.
Got it. So is it fair to say that one of the possible ways, okay, let me rephrase this. Is it likely that let me reframe it again. Is the most likely situation here that Tesla and Elon sit down and they properly define the relationship between Elon and the board, so that the plaintiff is happy, right? Let's just say that. And then they put a new plan to vote, either with the old package or the old package and a new package, or an old package and a new package separately, or no old package and a new package, right? Is that the most likely outcome, that Tesla just says, okay, great, we'll just get a new plan out there and just be more transparent? Or do you think there is a different, more likely outcome here?
I'm going to object that the question's vague and ambiguous and compound.
Okay.
Yeah.
I don't know what that means.
Yeah. So I would say that if I would, if they hadn't been working on a new package, which I believe they probably have. I think this is in the works. If they hadn't been working on a new package, they're going to work on a new package and get it done, because they think they can circumvent, at least I believe, they could circumvent the court's order by complying with it and just doing it. And they could still appeal, so it doesn't stop them from appealing. And they could always withdraw the appeal. So let's say, they decide down the road they don't want to pursue it. And they could also put a provision in the new agreement that would say, if we go and appeal and we're successful and that period gets reinstated, then this new agreement won't cover that new period. So they could deal with all this. And I would think with their lawyers, because they really have some high-powered lawyers in-house and outside, that they have worked on this and are working on this.
Okay. And actually, I had a question from before. I forgot to ask it. So when Elon and Tesla came out and said, we're waiting for the ruling to come through for this pay package, right? Did they have to wait because of legal reasons, or did they wait because of logistical reasons?
Yeah, I think it's for practical reasons, because they wanted to know what the ruling was, because for this exact reason. Do we have to deal with that 2018 period or not? And because they wouldn't know what issues, maybe she would have ruled in a particular way that would have capped the way they could compensate him. And so I think they were waiting just to make sure that they didn't do something that was specifically going to be against her order.
Got it. Okay. So for some reason in my head, I thought the reason why they were waiting is because something from a legal proceeding standpoint was saying, hey, you got to wait before you get a comp package out there. We got to wait and we got to wait for this to finish so that you can legally put a new one in place. But that's not the case. It's just more like, hey, Okay, got it.
Yeah.
So it's about like, okay, so doesn't that mean that because they were waiting, doesn't that mean that this new comp package will be inclusive of the previous period?
I think absolutely.
Yeah.
That's what I think. But maybe you cut it up. Maybe there's a reason you do it to that. You kind of cut up the old one and you do a separate new one. But but as the point you reference, it's something they were considering, obviously. So I'm sure they played, because that's what Elon is paying these guys for. They're going to sit around a room. They're going to figure out, here's 25 different scenarios. Let's figure out what would happen, what we would do. So I would assume they've already figured out that this is a possibility. We could lose, and we could lose like this, and she could say that, and what we would do. So I think all of this has been pre-planned.
Got it. And so the biggest damage here, it seems, is obviously there's some sort of issue between, I'm just going to paint out what I think the biggest damages are from this entire thing, and then you tell me if I'm thinking about this correctly. The first one is that there's going to be additional scrutiny on Tesla when it comes to the relationship between Elon Musk and the board, if people find that there's some conflict of interest going on with this stuff. So that's one. The second one is that Tesla is going to incur some legal fees that it would have never had to incur, which are related to what the order saved Tesla by rescinding the $55 billion comp package, which could very well be re-implemented with a shareholder vote, which means that Tesla is out the lawyer fees, right? So Tesla's just out money at that point, which I find hilarious. And then the on the flip side, Tesla is now able to draft a comp package that for the future, because now they much better understand what the next step should be, that would give Elon what he wants, which is at 25%, and compensate him fairly, that meets the criteria that the court outlined based on this ruling, if they decide to remain in Delaware.
Yeah. And I was going to say, on top of that, I think that's fair. And on top of that, I think she specifically didn't void or cancel the fee agreement. She just rescinded it because she thought if she voided or canceled it, it made it more likely for her to be reversed on appeal, because there's no reason that a properly termed and disclosed fee agreement shouldn't be upheld. So she can't withhold that as a possibility for the board and Elon to do now. So if she would have done that by canceling or voiding it, I think that was her concern, and that's why she used the rescission, which I think again has its own problems, but I think that's why she went that direction.
Got it. Okay, that makes perfect sense. Okay, got it. Okay, so that's extremely helpful. I think I understand what has happened much better. I have more clarity on what the steps forward are going to be for all parties involved, most likely, but it could change at any point. What are the complexities of running of an appeal and drafting a new comp package, let's say? And is Elon asking 25% control now that the judge has sort of used, again, once she identified that Elon was in control, whatever that definition we were using, and how much he owned or got paid was part of the ruling, is there a concern here that Elon would not be able to get the 25% he wants because of the ruling that was set from this court case? Yeah,
I mean, interesting point. So this might depend upon when they move. So they're going to reincorporate let's say they reincorporate it in Texas. So until they do that, they're governed by Delaware law. So would you want to have a comp package in effect while you're still governed by Delaware law? Probably not. Which means probably when Elon said they were thinking about reincorporating, probably by Friday of this week, they'll be reincorporated in Texas.
How long does that take?
Yeah. You could do it. I mean, you could do it instantaneously. It's not like a few days, whatever. It shouldn't be a complicated task. But once they go to Texas, I would expect then the package to be done, because then they would be governed by Texas law. And just to kind of follow up on that, and I think Alexandra asked this yesterday, the appeal would still be governed by Delaware law, even though they moved to Texas. But I would expect, and there may be different lawyers, by the way, working on both. So the package might be by some group of transactional lawyers, and the attorneys doing the appeal may be a completely different set of lawyers from a different firm, but they will be communicating to make sure that they're on the same page, so one doesn't do something that might impact the other.
Okay, that's helpful to understand. Another question on that. So if Tesla were to reincorporate to Texas, say as of this Friday, once they file the paperwork or whatever they need to do, and when they draft, so since it's rescinded, if they choose to draft an amended pay package that pays Elon for what he's, let's say, owed for the last 6 years of him hitting the tranches, either at the 55 billion or not, would that new comp package have to be, is that new one going to be ruled by Delaware, or is the new one like the unrescinded version, will that be under Delaware jurisdiction or Texas jurisdiction if they were to move?
Texas.
Because it's new.
But if you were going to appeal and you didn't kind of clean up your act, it would probably hurt you on the appeal, even though it really shouldn't. But let's say Delaware is looking now at this Texas company. They're not supposed to, but they probably will. And let's say they thumb their nose. Let's say Tesla thumbs its nose at Delaware and just continues as business as usual. They don't change any of their practices. It probably would hurt the appeal from a practical standpoint. So I still think they probably would follow it. And by the way, I think it's probably a good practice because, listen, being a Tesla shareholder, in essence, there's obviously people that don't like Elon and would be to the contrary, but probably 75% you could disclose whatever, whatever, completely transparent. He's getting 100 times more than anybody else. His brother, his uncle, and his aunt are on the board, whatever, and they're going to still vote. So I think it's a good idea just to conclude it, because it's kind of, you've now been like more transparent than anybody else, and there's no harm, no foul, because you're going to get whatever you want anyway. But theoretically, you wouldn't have to if you were governed by new law in Texas.
Yeah. What I find most interesting about this is that I think it would be safe to say that if Tesla is held, let's say, to this standard with some of quote unquote shenanigans that they pull to get this deal forward, I would be shocked if 100% of other companies can't be held to a certain level of standard, and every single one of them would lose in this if they were in the same shoes as Tesla is. Is that a fair statement to make?
Not only a fair statement, but we have a test now, right? If we are correct, we will start to see a whole abundance of new class action lawsuits being filed in Delaware against a whole myriad of companies using this theory as the basis.
So you should go to school for law, is what you're telling me.
Yeah, but you have to live in Delaware.
Okay. Yeah. Millionaire Delaware. Oh, that's hard. That's a hard. Yeah. No, shout out to Delaware. All 20 people that live there. Okay. So that was my question about the way forward for other companies. Okay. So, it's going to be really interesting to see if people will reincorporate out of Delaware because of this rule. I'm actually very, very interested to see that. Yeah. Is there anything else you wanted to mention before we take more questions from the crowd?
No, well, I just give you I had a list of possible solutions. So we talked about an appeal. We can have an appeal with a new agreement. So you could do both. On an appeal, the shareholders of Tesla can participate by filing briefs. They could decide to skip the 2018 bonus period entirely. So Elon could say, let's skip 2018. Let's start at 2024. And, they can incorporate what he lost in a new plan. They could lobby, and this could be everybody, since I've had experience in groups that do this, and it does have some impact, and we are in election season. You could lobby senators and congressmen, because you're going to certainly have a lot that will be supportive because a lot of people think this is a direct, improper intervention in capitalism. That companies should be able
politically
to
charged. Yeah.
companies should be able to govern themselves. So there's a lot of people that were going to be unhappy with that, and you certainly can incorporate in other states and try to take the laws out, and that's what they're going to do. Those were kind of some of the possible scenarios.
Got it. Actually, I find a very interesting question here. Why isn't Joe Biden, who was Mr. Delaware, commenting on this case? Do you expect the president to actually make a comment on what just happened here?
I don't know if the president currently knows where Delaware is.
As a Democrat, right? Spoken
as a Democrat. As a Democrat.
That's amazing. Okay. See, we're part-time education channel, part-time comedy show. You're welcome, everybody. Okay. All right. Can Tesla issue post-IPO dual-class shares if Tesla incorporates in Texas? This might be a little bit of a very specific question. Are you familiar with this field?
I don't know. I'm not a security specialist, so I'd just be purely guessing.
Okay.
I guess yes.
Okay. Okay. What started all of this that they felt they needed to reincorporate? I mean, I can sort of. Do you want to summarize it real quick, Richard?
You could. Let's hear it from you.
So what started all of this? Let me switch over. Okay, I feel like I'm going to. Will this count as my bar exam if I say this correctly?
Actually,
okay,
it's
cool.
funny is the way I've noticed that the way you've asked questions. You've asked them much more like a lawyer. You've actually rephrased questions multiple times. It's very interesting.
Thank you. I appreciate that very much. Yeah. I don't know what any of that means, but I appreciate it. I don't know if that's a good thing or a bad thing. So they feel that Delaware. So when I say they, I mean Elon Musk and Tesla don't feel, specifically Elon Musk, doesn't feel like the Delaware court ruled appropriately in this case. He feels like they missed specific things that were related to the comp package that did make it valid, and it shouldn't have been rescinded. And I don't know if there's any other personal reasons why that might be involved there. But then, based on the court ruling from Delaware, Elon is deciding to say, okay, I don't trust you, Delaware, when it comes to upholding business cases, and I feel like you might be quote unquote targeting me, and so I'm going to move my business to Texas, which in theory is going to have more friendly rules to businesses than Delaware. What do you think?
Yeah, I agree. And by the way, to those that want to make sure Elon gets his pay package, I spoke to Farzad about this earlier today. We've been designated as the collectors for Elon. So anyone sending money for Elon, please send it care of Farzad and not legal advice.
Yes, thank you. I really appreciate that.
Yes.
Definitely 100% serious. All right. From the GOAT, Larry Goldberg. Thank you, Larry. Isn't it necessary to appeal regardless of whether Tesla builds a new plan or not, simply to attempt to save the $5 billion of likely fee award? I don't know if that number is correct, but love to hear your take on that.
Yeah. And Larry's a super sharp cookie. So
he's also so sweet.
Yeah.
Oh, my God.
Well, that part I don't know, but I know he's super bright. So the question is, I would say generally, yes. The only downside is if you think you're going to lose, you wouldn't appeal because you wouldn't want to set the precedent. So sometimes, even though you think you get screwed, if you think that the appellate court is going to uphold, and we don't know yet because we don't know who the panel is going to be. So the way it works is you file a notice of appeal, and then a panel who's going to and that'll be generally it's a 3-judge, a multi-judge panel will be on the appeal side, and you may not have a feel about what your chances are until you see who the panel is. So I agree with you 100%, Larry, except if their lawyers conclude that they're going to lose the appeal.
Okay. Thank you for that. Alexandra, could Tesla do a merger with a newly formed X holding in Texas rather than just a domestication, then have Elon hold 25% of the holding? How long does a possible merger take?
I'm not an M&A guy, although my son is, but I'm not. Yes, they could. They certainly could form it in Texas. And my guess would be I don't know the notice periods. That's in terms of like preparing the paperwork. You could do that. You could have a firm working all weekend. You could do the paperwork, but I don't know in Texas what the notice required would be if you have to give public notice before you're going to do a merger, and then I don't know what the SEC would require. So if it was like springtime, that sounds like that would be too fast. I think you would probably need more time. That's my guess. But as to the merger and forming, I believe the answer is yes.
Okay. Do you think this will impact companies' decisions to incorporate in Delaware, and has this hurt Delaware going forward? I hope it has. LOL. We talked about it briefly, but maybe give your take again here.
Yeah,
Richard.
I think it's already done. I think, from this day forward, companies are, one, not going to incorporate in Delaware if they have a choice, and two, we'll start to see a flood of companies moving out of Delaware.
Okay. This is actually a very interesting question, which I forgot to ask. What is the reason? Why do many companies incorporate in Delaware?
Yeah. So originally, when I went to law school, it was a state that didn't permit lawsuits against corporations in a very easy way. It had certain privacy provisions. It had certain documentary protections. So they were deemed that was the place to go, because if you were a corporation, you were most likely to get impacted the least from lawsuits and negative consequences by incorporating in Delaware. So over time, it just became the place to go. And I think what happened is it became a habit. So even as opposed to thinking about where to go, people just started incorporating. And so now they're going to be thoughtful about it, because there's other states that provide those protections, and some states where the names of the owners are kept confidential. In an LLC, they might be confidential. So there's certain benefits, but it's just based on how it was 40 years ago, and I think habit.
Okay. I'm going to bring this up real quick. Stephen, thank you so much. Give Farzad Richard Elon's money. Just kidding, but love your content. Appreciate you to cutting through the FUD and helping to clear this up for us plebs. I mean, I would say this is much more Richard. Richard's background has enabled us to really, has enabled me specifically to really understand the why it was ruling the way it was. I'm not necessarily here to try to build an opinion per se, but I'm just trying to understand what the hell happened, because it seems complex and I don't really understand it as well as I should. So this is more for Richard more than anything. So thank you, Richard. Appreciate it.
Farzad's always the great questioner. So that's always a wonderful talent he has.
You're very kind. Thank you so much. All right, let's do another one here. Am I stepping on your toes time-wise or no? Are you good?
No, we're good. We're good.
Okay. All right. Which of those options will result in the lawyers getting paid the least amount of all the options that you outlined?
Oh, well, if they win on appeal, if they do the appeal and they prevail on the appeal, that means plaintiff's counsel gets zero. And Elon's counsel gets paid, which means Tesla has no legal fees. So that's the best consequence.
Okay. For worst consequence for the lawyers.
Worst consequences for the lawyers, and then, best consequences for Tesla's pocketbook.
Right. Again, what I find, and I want to reiterate this point because I think it's so important. In the event that Tesla were to pass. So after it's rescinded, they redraft the compensation package if they're capable back to 2018, and they for the same exact amount, and shareholder even with their new transparency and saying there might be Elon and the board are close, blah blah blah, whatever the plaintiff asked and they agree to. And they could theoretically put the $55 billion to vote again. The shareholders could agree to say yes. $0 change for the future payout for Elon, and Tesla would have to pay on the order of $1 billion in legal fees. That's a correct statement, right?
Yeah. Yeah.
Okay. All right. I just want to highlight that
because
that
good news
sticks out. That's the good news. All right. After this ruling, what percentage of Tesla does Elon own? I believe it's the same, right?
Yeah, because he didn't exercise the options. So
yeah. Okay. This is for future pay, not necessarily what he's got paid so far. How is the probability of the reward not taken into account in the value of the compensation?
The judge said that she did, and she.
And sorry, Richard, can you help me understand this question better? Because I'm not sure I understand this question exactly.
Yeah, I think what he's asking is the milestones. Did the judge factor? How did the judge factor in the likelihood that he would be able to satisfy the milestones to judge the value of the compensation, whether it was fair? That's how I read the question. And she said, and I don't remember specifically what evidence she pointed to, but she said it was discussed and it was known that most of those milestones would be easy for him to reach. And so her probability was that it was likely that everything was going to be reached. Therefore, the value should be less.
Even though at the time, if you go back and read a lot of articles from media pundits and financial experts, a lot of them said that this would be an unprecedented level of growth for the company. Is that a correct statement?
That's correct. And by the way, I should throw one more thing. She also focused on the fact that he had other interests and he wasn't donating full-time to Tesla as a reason that his compensation was too high.
Got it. Which again, for me, is what I was trying to understand is how come a judge gets to decide that, and I guess she has the power to decide it in Delaware.
Yeah,
that's just how it is.
Yeah, she's deciding fair amount, fair process. So she's looking at facts, which she think show that.
Yeah. And I think the thing that I'm trying to differentiate is what is the right thing and what is just the thing that happens under the current system in Delaware. So she has the ability to say those things, and thus she did, and that was her ruling. And so then we can have a separate discussion about was that the right ruling or the wrong ruling, right? Yeah.
And again, I think it was controlled by her finding that he had control over the company, which made him have the burden of proof.
Got it. Okay, let's do a couple more here. How do we go back in time and make shareholders from 2018 vote?
Yeah, that's a good question. I mean, what happens some shareholders probably passed away, right? And they can't.
I hope not.
I mean, that's my question. That was exactly my point. I don't think you can really rescind this transaction because I really don't think you can put everybody back in the same place they were.
Mm-hmm. Okay, can we role play that a little bit?
Sure.
So, okay. So what do you do with the prior pay then? Isn't the outcome just appeal because of exactly that reasoning? Is like if I go back in time 6 years, the people that voted yes for the money that he's already entitled to because he hit the thresholds based on what the shareholders based on the shareholders voting yes. Is there a fair way to go back 6 years and put everybody in the right frame of mind and revive people that may have passed away that no longer exist and involve new investors that weren't there in 2018 and have those same people vote on that as well within the context of what was going on for the company back then? It's so weird, right? Isn't that weird?
I don't think so. And
okay.
I don't. And I think she doesn't care because I think the message she communicated was, he's got 21.6% of the company. He doesn't need any more money. That's really what her message was. He's in essence, when he's bolstering the company's stock, he's bolstering his own pocketbook. I don't understand why that's relevant at all. The fact that you're an owner and you benefit, because you benefit all the shareholders too. And you have a fiduciary duty to your shareholders. So what are you saying? You shouldn't be bolstering the stock value for the shareholders? I didn't really find that to be a pleasant argument.
Okay. That's, again, every time you say that, it sort of just makes me question a lot. Okay. And then let's make this the last one. Will this need a special shareholder meeting as the current shareholder meeting is not too far away?
Yeah, I would say, I'm not the attorney, but I would think, I don't think there's enough time before the current one to do everything you need and to make sure you cover everything. And also, in reality, again, we don't have a final ruling, and you probably want to see the final language before you take any further action.
Okay. All right. I think we're good there, because this helps me build a foundation on how to think about a lot of things, let's say, here. And so I really want to thank you, Richard, for the service you've just done for all of us, and donating your time to this. I owe you a lot of beers after this. I really, really appreciate it. And any last sort of thoughts or commentary you want to add here, as long as you want to go, because I think whatever we can bring forward for us to better understand this would be great.
First, I would say is Confucius says, women who sit on judge's lap get honorable discharge.
Oh, Jesus. Oh, God. All right. Next. Let's go. Keep going.
All right.
God. Jesus.
I have nothing else to add. I'll leave it on that. If you have any questions, or anybody else have any other questions, I'm happy. I'm happy to answer.
Okay. Wow. That was
that's the edited part, right?
Woo. Well, we're live. Okay. All right. Where can people find you, Richard? If they want good legal advice. Not
legal advice with a K, at rah999. Please join me, and I answer any question. So if you have a question or a comment, I will answer. Or it might be like one of those answers I just gave that turned Farzad red. I've never seen Farzad that red.
I love how professional we were for like 98% of that stream.
Yeah, you notice I
yeah.
withheld it. I kept it.
It was beautiful.
Yeah.
So we can really hold true to the fact here that this is part professional, part comedy, you know?
Yeah.
And we're not sure if it's good comedy, but it's comedy.
That part I can't guarantee. Yeah.
That's fair. Okay. All right, everybody. Thank you so much. Make sure you go and follow Richard, Not Legal Advice on YouTube, at raw999 on X. Please come on again. If we should do this as often as we need to ensure that we're understanding this. And the other things I want to explore too, I think, is how this will impact, again, just Delaware in general.
Yeah.
Because I think yesterday I was thinking about this within the frame of Tesla and what it means for Tesla, but this is a decision that's very far reaching, just because of the amount of corporations that incorporate in Delaware.
Yeah, I was going to say, and it'd be interesting to see, because if the trend is that new companies go to particular states, it's going to change the way that corporations operate, because they're going to be operating under a kind of a different set of standards, which are going to be more favorable probably to the corporate structure. Yeah. Okay. All right, everybody. Not Legal Advice. Go check them out at raw999 on X. Thank you so much for stopping in. Love you guys. Bye-bye. Bye-bye. And